It provides as follows in respect of all the premises. A police official may, without a warrant, may search without a warrant any premises for the purposes of seizing any article referred to in Section 20. A, if the person consents to the search for and seizure of the article in question, or if the person who may consent to the search of the premises consents to such search and the seizure of the article in question, or if he on reasonable grounds believes that a search warrant will be issued to him under paragraph A of Section 21(1) if he applies for such warrant, and 2, that the delay in obtaining such warrant to defeat the object of the search. And similarly, Section 29(1) of the MPA Act also does provide for similar provision. I think it would be appropriate if we go to look at paragraph 26 of the opinion, where we make the point that the cure that the President thinks might very well circumvent the difficulties would be, for instance, where there is an application ex parte, it would create a less restrictive means. Around that point, we make the submission that the President suggests that the elements of surprise can be met by allowing warrants to be issued without notice to other parties, that is, ex parte applications, and cites the Estate Agency Affairs Board judgment in that regard. In our view, however, that contention is misplaced, we say, and we say with respect. Ex parte applications are indeed an effective way of maintaining the element of surprise. That is why, as a default position, warrants are generally required. That is the point made by the paragraph 39 of the Estate Agency Affairs Board decision. But the question of a default position is quite different from the question how urgent searches are to be dealt with. And we say that the suggestion of using ex parte application does not resolve the difficulty of urgency that is sought to be addressed by the proposed Section 45B1C, and indeed by Section 22 of the CPA and the court's reading in orders in those judgments. Those provisions seek to address the situation where the person conducting the search fears on reasonable grounds that by the time the application for a warrant has been prepared and granted, the evidence consent will have been concealed or destroyed. In other words, the purpose of the search will be undermined. Using ex parte applications cannot assist at all in this regard. Fourth, we say if there is any concern about the breadth of the search, this is resolved by a process of interpretation, including reading down. The concern raised by the President that the proposed section does not require that the FIC must specify that the inspector may only search for or require the production of information related to the business to which the provisions of the Act apply. The President seeks to contrast this with Section 22 of the CPA, which specifies that the search consent must be for the purpose of seizing any article referred to in Section 20 of the CPA. We agree with the President that this is important, that those conducting a search of this type only search for documents relevant to the purpose of the search, but we do not agree that the mere fact that the proposed section does not say so expressly creates a constitutional difficulty. Under those paragraphs, we make the point that it is possible to give a contextual interpretation that can read that requirement into the section as it stands. And we say against paragraph 27.5.3, in our view, these provisions make clear that a warrant-based search, in terms of the proposed Section 45B1A, the person conducting the search may only search for information pertaining to non-compliance with Fica and the relevant directives thereunder. Just so as to make sure that we can give our opinion pithily, we look at the reason why it is that we say that the the proposed bill in its form will pass constitutional muster, we say, unlike those provisions that were struck down by the Constitutional Court as being overbroad and unspecific in relation to how those searches are conducted, the proposed bill has mitigating element about it. And we point those out in paragraph 28. Yes. In paragraph 28, we make the submission that Section 45B1C must be read with the constraints imposed by the proposed Section 45B1D. And we say the proposed Section 45B1D constrains the manner of the warrantless searches. It stipulates that the search must take place, 1, at a reasonable time, 2, on reasonable notice where appropriate, and with strict regard to decency and good order, including to a person's right to respect for and the protection of dignity, freedom and security, and personal privacy. This element of the proposed bill and the proposed section then addresses itself to the concerns which the Constitutional Court has expressed in relation to warrantless searches. It then begins to circumscribe the method by which the purpose of the Act can be achieved without necessarily offending the provisions of the right to privacy that is protected under Section 14. And we say that is a further safeguard of the right to privacy. Indeed, it's a safeguard which goes beyond the safeguards contained in Section 22 of the CPA and the reading in orders granted by the Constitutional Court in Gardner and in Estate Agency Affairs Board. But we say that there may very well be additional manner in which the concerns of the President may be addressed. Having concluded that that section is consistent with the Constitution, it is our view, again, that National Assembly would be perfectly entitled to simply reaffirm the bill in its existing form. In the event, however, that the National Assembly wanted to, it could also amend the bill to make expressly clear the limits of the searches under Section 45B1C, and it could do so most easily by adding an additional subsection to the proposed Section 45B1D, and we propose as follows. That Section 1D would read, where an inspector enters premises without a warrant, he or she must do so, A, at a reasonable time, B, on reasonable notice where appropriate, and C, with strict regard to the decency and good order, including to a person's right to respect for and the protection of dignity, 2, freedom and security, and 3, personal privacy. But the D that we propose would then read, only for the purposes of determining compliance with this Act or any order, determination, or directive made under this Act. That we suggest would put beyond doubt the constitutionality of the proposed provision and will survive constitutional muster, however, whatever constitutional scrutiny is placed on it. Chair, may I deal lastly with what the Constitutional Court in the various judgments had said in relation to these warrantless searches in circumstances of urgency. And we say against paragraph 2511, the principle that this kind of agency justifies dispensing with a warrant requirement is put beyond doubt by the series of statements made by the court regarding section 22 of the CPA. In Mahajani, the court cited section 22 of the CPA as an instance where, in quotes, warrantless searches are justified. And in Gaitna, the court held that the law recognizes that there will be limited circumstances in which the need for the state to protect the public interest compels an exception to the warrant requirement, and cited section 22 of the CPA as an example. In Ngukumba, the court made clear that police officers are generally required to comply with the warrant requirement, but then held that, in quotes, where there is a need for swift action, the police can always invoke section 22 of the Criminal Procedure Act. And more recently, in Kunjani, the court held that section 22 of the CPA, quote, provides for a constitutionally sound warrantless search procedures. So it is quite clear that on the existing jurisprudence, a warrant requirement may be dispensed with in urgent situations. As the cases cited make it clear, it is so even in respect of searches of private homes and even where criminal offenses are involved. Yet this is precisely what the proposed section 45B1 seeks to do. Is it okay? Yeah. So in summary, our considered opinion is that there is sufficient safeguard to survive a section 36 scrutiny of the proposed section, Chair. And it is for that reason we come to the conclusion that the proposed section will survive constitutional scrutiny and pass muster.
I apologize, Advocate Semenya. I'm busy on the SMS, not because I'm not listening, but I have loftier matters to deal with. The catering for today is for 40 people, and there are 4,500 of you. So it's a hurdle because, you know, the House Chair, he's got nothing better to do. He has to approve. Then I must send an SMS because I can't send an email. So I've got loftier things than whether this bill or this provision is constitutional or not. But you may laugh, but when it comes to lunchtime, Advocate Semenya, I'll be more popular than you. Right, having said that, let's move on to the next. Jeremy Gauntlet, Advocate. May I take this opportunity to congratulate you on your appointment as a Queen Counsel. I know some people might have ideological issues and so on about it, and this is a free country, and they can, but for what it's worth, I think as a South African and as a fellow South African, at least on my behalf as a chair, I would like to congratulate you. Committee decision, no need of hands to be raised and so on. I hope one person in particular is listening, but I won't needle him. Okay.
Thank you, Chair. I'm grateful for your kind observation, and I take it that it carries with it no reference to colonialism or anything of that order. Chair, an advantage of the process that has eventuated in this committee, even if not desired in December, is that you have before you now a number of legal inputs. All these inputs, so far as I'm aware, have been independently arrived at. I certainly know that, speaking for myself, and I know my colleague, Mr. Semenya and Mr. Budlander, we have not interacted on this matter. And I think that's of some importance to the committee, because what you have before you is a very high commonality of view in the ultimate result. Indeed, from what I have seen in terms of the inputs, there is one variance, essentially, one different direction which is taken by one submission. I can curtail a great deal of what I would otherwise need to say to indicate that arrived at in this way independently, as you would have seen, as members would have seen, honourable members would have seen, the advice which has been given to Treasury arrives at the same conclusion as the independent advice to Parliament, essentially. Our advice is in a few respects perhaps a little more conservative for a reason which I shall explain. But the bottom line of it is that the fundamental objection or reservation which is raised regarding the use of warrantless or the legislating for warrantless searches is unconstitutional. In our respectful view, is not sound. There are subsidiary matters where we believe that the reservations which have been tabled by and behalf of the President, while not cutting to the quick of the bill, could, and we would respectfully suggest, should be taken on board in the form of very minor procedural, essentially, adjustments. As our learned friend, my colleague, my brother, Mr. Semenya, said in conclusion, and you would have seen it in the last paragraph or so of Parliament's opinion, paragraph 29 and 30, that the Assembly could, if it wished, also amend the bill to make express certain aspects. And that's important because honourable members asked earlier for effectively a short outline of what the President's objections are. And we summarize those in paragraph 5 of our own advice on page 3. And what they essentially are, that together his concern is as to whether the bill meets all the concerns noted in the Constitutional Court judgment, but the two real reasons in paragraph 7 relate to the fact that searches may result in criminal prosecution, and the indication, the view offered is that really that's a no-no. And we share with our colleagues that it's not a no-no. This is a different context because it goes to compliance, regulatory compliance, but even in a criminal context, as my learned friend Mr. Semenya so well explained, it is not an in principle no-no. So we would respectfully submit, going a little bit ahead of what I have to say, but it's always helpful to know where a person is going, that ultimately the choice for this body is really one of three things. One is to say that on the advice taken and on the views of members through the consultative process, it adopts the viewpoint that you can never have a warrantless search. We would agree with our colleagues that that is not what the Constitution requires. It's not what the Constitutional Court has said. It is recognized that, alas, in life, there are sometimes circumstances when the requirements of the Constitution would recognize that it is necessary to proceed without a warrant. As the Constitutional Court warns, in exceptional circumstances, but still, in principle, then, yes. And then the second question which arises, that if that is so, in relation to the subsidiary points raised by the President, are they not to be, as it were, taken on board, or are they to be taken on board on the basis that essentially they go to a proposition which is this, that the concern the President has, or is expressed in his letter, is that there are certain aspects which may be implicit in the bill. And a very good example is the last, on going to our colleague's opinion on page 31, the provision which they suggest be added if the committee is concerned and Parliament is concerned, that what the inspector does in going onto premises is only for the purposes of determining compliance with this act, etc. And we fully agree with them that that is axiomatic. If I have a power under the Rinderpest Act, I cannot use it to fight jackals. It goes back a very long way. A statute, even pre-constitutionally, maps out a flare path for the police, for right holders, for people against whom it matches. And you can't say to yourself, do you know, it's a very good idea. This is such an excellent provision. I know I'm giving it to fight rinderpest, but let me take it and use it to fight jackals. It's a rule of law point. Parliament didn't give you that mandate. If Parliament wishes to add jackals to rinderpest, it must do so. But this is an act, the whole purpose of which, and it's spelled out in section 44B1A, is to determine compliance with itself. So we agree fully that it wouldn't be necessary to spell it out. But this committee will determine, and whether Parliament determines, that when aspects are raised which require a small adjustment, which meets what is tabled as a concern, and which, and the point would not be lost, I'm sure, on honourable members, would remove the oxygen from an attempt to attack the particular provision by saying, let's not wrangle about the words. If your ultimate point is it doesn't say it, well, then we'll say it. So already in the Act it says the powers are for compliance, to be exercised for compliance with the Act. But the example and the proposal made, as we have done in our addendum, proposed a text for your consideration, is in respect of the second category that the President raises, is, as I put it, to remove the oxygen for political combustion, and for legal combustion, I mean. That was a Freudian slip. For legal combustion, why have a fight when you can meet it on words? Why set up on a plate potential challenges by third parties? Because you will know, and it's a thing which was said in the first Constitutional Court judgment in Makunyane, the Constitution, unfortunately, doesn't just protect the good, it protects the wicked. And it's the reason why in the United States, an important test case was involved a neo-Nazi group marching through a Jewish neighborhood. Offensive in the extreme. The question was whether there was free speech in that setting. So here, I'm respectfully suggesting to the committee in the second category that the adjustments be considered and taken on board, where the committee and Parliament, if they're satisfied, that it does not detract in any way what Parliament advised would wish to achieve. Chair, may I just briefly highlight then the main aspects which are, in our opinion, before you. Before I do so, might I just say in a sentence that we would respectfully agree very much with the important antecedent procedural analysis by Mr. Jenkins, by Advocate Jenkins, regarding Section 79 and the important questions raised by honourable members earlier as to what is the stage now. And as indicated, the current Constitution took away the power of completely abstract review, namely going off to the Constitutional Court and saying, this is a terrible act. And the Constitutional Court says, but in what context does it arise? And the answer would be no context. It's just a terrible act. What the Constitution makers have done in taking that away, have put in place a unique role for the President. And like many of these roles which straddle the division of powers, it's not without its problems, but its functionality is that the President, who otherwise would be required simply to sign off on things, even though his advisors would tell him, but there's a real problem, is given the capacity not to, of course, to fix it himself, because that would offend fundamentally the division of powers and the power of Parliament in particular, but to send it back to Parliament to say, I have these concerns. And then, of course, it's the process in which you're in, which is either to say, concern considered, rejected, we carry on, or concern conceded, adopted holus bolus, or an intermediate position, which is the one which I'm respectfully suggesting, which is to say that the overall concern raised with respect, and it's on the advice clearly given to the President by the advisors and not a personal view of the President, but the reading of the Constitutional Court cases for the reasons set out in our opinion and highlighted by our colleague Mr. Semenya. The Constitutional Court doesn't say that. The Constitution doesn't say that. And that there may be instances in that exceptional instance contemplated also in the Tax Affairs Administration Act where you cannot reasonably get to a court to get to a warrant. What we have proposed for your consideration is taking very much on board Section 36 of the Constitution to which Mr. Jenkins referred, effectively saying if there's an infringement, which everybody accepts in principle there would be in the circumstances we contemplate, it's got to be justified and in relation to the least restrictive means which would achieve it. And we've proposed that the committee consider building in an intermediate stage between getting a warrant and going in without any warrant, which is that as long as it's reasonably capable of being achieved without frustrating the whole purpose of what you seek to do by way of search warrant, that you would go to the head of your regulatory body. Now, I know that's not a judge or a magistrate, but the point about it is it's still somewhere between duck and no dinner. It's an important constitutional safeguard. It would mean in many instances the particular exerciser of the power is not an individual human who is without that kind of assistance, etc., which is what has to happen at times when the most junior constable in certain circumstances has to take snap decisions without going higher up. But we've suggested that, as you've seen in the text, that that be considered as being built in as a further a safeguard. May I just very briefly deal with particular aspects? You would have seen that we've provided really for this tiered approach, and that is that ordinarily, if you depart from the viewpoint that privacy is to be invaded, you've got to ask the question, whose privacy? And we've suggested that, as with the TAA, Tax Affairs Administration Act, the important thing is the occupant. It doesn't matter who owns the premises. The particular part of it, which may be subject to this, may be an informal structure added on to other premises. The question is, who effectively would be the person through whose materials you would go? And it is best captured, we believe, in the word occupant. Secondly, that you should, in principle, as we've provided, in principle seek to obtain the consent, the informed consent, the inspector must explain, informed consent of that person. But thirdly comes the fire engine provision. And a lot of statutes need them. Democratic countries around the world with justiciable constitutions have them, as our colleague Mr. Semenya has also indicated. And that is, occasionally there will be instances acknowledged by the Constitutional Court and confined to the exceptional, where you would need to be able to exercise this particular power. The safeguard then lies in the fact that the exercise of that power itself can be attacked. And that's how often happens in our law. When you're determining the constitutionality of a provision, you don't presume slackness, dissipated, intoxicated carriers out of the power. Because the answer is, if you get that, that's where it gets attacked, at that level. And the Gertners and others in the future will come to court to say, this is what the particular official did. But what you do is try to put a constitutional mechanism in place which determines that the official will carry it out in the best possible way for constitutional compliance, which is why you would have seen that what we have sought to build in is a series, again on the President's point of, well, it may be implied, but is it? Is to say, well, then we'll say it. And that if somebody goes in, then Mr. Inspector, respect her decency, respect this, do the other. Many would say it's axiomatic because the inspector will be hauled and dealt with as having acted outside the law if the inspector acts contrariwise. But what we've sought to do is to suggest that these provisions, because we don't see them in any way detracting from the importance of the function of the bill, that they to that extent be taken on board. But we agree what's been said we agree with respect with Mr. Jenkins. We're here to look at the President's reservations. It's not an open sesame for reconsideration of the bill generally. It's not what Section 79 considers. But conversely, this committee and Parliament must of course sensibly be in a position to say, well, the President raises this particular point. We say to remove debate. We propose that this be changed. We adapt this on particular wording, and there'll be a knock-on effect. So all I'm trying to say is that I don't see that members have to sit here with a pair of scissors and only cutting around little bits that the President refers to. If there are other things that members are spotting as one goes through, then it is an issue which consequentially could be attended to. But it is not, as we understand it, and we believe with respect Advocate Jenkins is entirely right, it is not, as I've said, an open sesame for the whole legislative process. Imagine the President standing there effectively as a sort of second umpire, put there constitutionally, not as an umpire so much as a waiver of a flag, but to say there's a problem, please look at it. And that's what Parliament does. Parliament will speak, and Parliament will adopt or reject. But in so doing, Parliament would clearly, also having regard to notions we would suggest regarding the interaction of the arms of government, would seek where, to put it colloquially, there's no skin off one's nose, to meet a point with a tightened formulation, which is what we've sought to do in those provisions. So in conclusion, we respectfully agree with the legal advice that Parliament's been obtained, that the main point taken, i.e. thou shalt not have a warrantless search in the President's letter, is not with respect on a correct reading of what the Constitutional Court has held or the Constitution indicates, or the wisdom of other constitutional democracies. In principle, there can and there even should be provisions for such things. And why I say should be is it's important to note that in the President's letter, he states in his paragraph 7, which is the real core paragraph, that he accepts that the purpose to be served by the bill is very important and pressing. And those two words, or two descriptions, very important and pressing, with great respect, are correct characterizations of a situation amply addressed by a number of other stakeholders present here today, and which I need not further go into. But the amendment clearly, as the President indicates, is doing very important work. It's not rinderpest, it's not jackals. It's very, very important work, and it has to be seen in that context that it is proposed that minor adjustments be made if the committee and Parliament are so minded. Thank you, Chair.
I think we, members of Parliament, should learn from the lawyers. They have used up less time than they were allocated. I think a good 20 minutes have been saved. So there it is. Over to members. We will first ask members to raise questions, and then anybody else who wants to, who's making representations to this hearing. Thank you.
Sorry, Chair, might I just point out one typo which otherwise might have puzzled members, and that is there are a couple of errors done under the process in the constraints of time, but I used the word in a senile moment of arrest warrant instead of search warrant. I'm sure members picked that up, but in case I cause confusion somewhere.
Thanks. There we are. Members? Sorry? Okay, go ahead. Brandon Tandi, who's next? But Brandon and Tandi.
Chair, having reference to the two opinions and also all the later opinions which you've read, I think the most remarkable thing is the consistency of the legal arguments, that they don't necessarily oppose. I think it's common cause. Everybody agrees in this committee. When we debated the bill last year, we all raise concerns of the limitation of people's privacy. And we considered, although not in such a formal manner as these legal opinions, many of the legal issues raised. And at the time, we considered that the clause was past the constitutional muster. Having read some of the opinions which are coming later, the minority view is that sections of this act are unconstitutional. I think it's clear the breach of privacy is at face value a breach of the Constitution. However, in all the legal arguments, Section 36 is covered by most of the legal arguments, as well as, most importantly, the two cases, the Gartner case and the State Agency Affairs versus Auction Alliance case. So maybe to help our committee, those people that do not share the view of Parliament's Council, of Treasury's Council, or even of BAS's Council, should spell out why they believe that the Constitutional Court would find against its own provisions, because this clause 45B1C or whatever is basically a verbatim clauses as the Constitutional Court has already found in favor of in that case, and the subsequent amendment of the Act, as well as in the Criminal Procedures Act, and then also very similar in some ways to the Tax Affairs Act. So if they can spell out to us why they believe that this case or this bill is specifically different in some way to these two already constitutionally tested cases or acts. Thank you.
Thank you very much, Chair, especially to the two senior counsels. First, I'll make a comment that I always make when we listen to legal advice as Parliament. Yeah, I'm speaking to that. It's right in front of my mouth, Chair.
Explain, colleagues. The IT system has collapsed, and on this side, it doesn't function. I think on that side, it does. So I'm sorry about this, but really, there's nothing we can do. Yeah, thank you.
Am I audible now, Chair? Yes, I'm trying to say to the to the senior counsels, there's particular comments I normally make here in Parliament when I listen to legal advice. And I always say, when you listen to lawyers and advocates, they always have different opinions. And the best place to test their opinions is in a court of law. In this case, it's a very interesting matter because it's a matter that involves the Constitutional Court. And amazingly, for the first time, you have two senior counsels agreeing. It's amazing, given the same. Well, it's a miracle. I believe in miracles, Chairperson. I believe in miracles. So it's a miracle. But I want us to get to the gist of the matter. The gist of the matter is how you measure what can be described as an element of decency in a context of invasion of privacy of individuals. When we're speaking to warrantless searches, there's a misconception that a warrantless search will be a witch hunt. Now, the Constitution is very clear in terms of how it stipulates the conditions. But to me, it's the measurement thereof, and at what point you come to the conclusion that you have observed the privacy of an individual in a situation where the operations are in private residences. And that's what we need to be clarifying, so that when we say this will pass constitutional muster, we'll have tested it. We're not lawyers as members of Parliament. So our arguments is on the basis of the advice that you give us. So, but also to clarify that there's a different context altogether to this warrantless searches, because they don't relate to seizures. So the misconception is that it relates to seizures, which give powers to different institutions altogether as opposed to the officers that the FIC will delegate this responsibility. Now, it's an issue that we need to clarify, because it it doesn't take away the element of surprise that you want to put in place, the reasonableness of time, the reasonableness of notice, because there's a balance of the rights of individuals to privacy in the rule of law. And that's the overemphasis that we might want to make beyond just explaining the warrantless searches, the balance between privacy and the rule of law, the limitless of the privacy of an individual in terms of the application of the law. That's the context that has brought us to the situation we find ourselves in the current conjunction. Now, the justification of the searches might be the issue, and that's why I'm worried, because we should not be entering into those type of discussions in this environment of legislative processes, where we justify at what point we'll consider a warrantless search as justifiable. It's the measurement that can be left to the Court of Laws, because they will determine whether there was an element of decency, reasonableness in the operations of officials. So this misconception by lawyers, Chair, in how they interpret this specific clause 36 of the Constitution when it relates to Section 41 that you're about to implement. I don't find a different view so far. So I want that clarity to be made in terms of the balance, so that when we move beyond these discussions and we look at the consistencies of this section with the Constitution and that passing the constitutional master, would have clarified even those misconceptions about the balance on the privacy and the rule of law. Thank you.
Is that right?
Oh, thank you. Chair, like the President, I concur with him. I mean, this bill is important and pressing. However, Chair, there are just a few areas that are of concern to me from the two speakers. One, I have not heard them say anything about Chapter 11 of the Constitution, and that relates to the security, the security cluster, if you like. It pronounces itself there. And the two, excuse my ignorance, where do these inspectors reside? Where are they located within the security cluster? We have to understand that, because we also don't want it to be found wanting when it comes to enforcement. We need this bill, like yesterday, and it's very important. But I'm not sure if we have spoken to that. I think the limitation of the two presentations, Chair, have been more on the invasion of privacy, and I think you've dealt thoroughly with that. Now, I'm more concerned about the institutional arrangements, what is envisaged, because probably those are maybe areas that may be of concern, Chair. Thank you.
Thank you, Chair, and let me also thank the two advocates. As one of my professors used to say, is that I'm much wiser after having listened to you. Can I then also stress this one, that this bill, it's our bill. It's because we believe that it should come. There should be no doubt about that. That as the ANC want this bill, we want this bill, and we want it yesterday. So that's very important. As Comrade Makosi has said, agreeing with the President. So there should be no doubt. It's because it went through. It's because the ANC wanted it. Mine, it's okay. Perhaps just to show how important it is, Advocate Semenya and Conclet, when the two of you were making your presentations, you could have heard the penny drop, because that's how attentive we were. But I just want to, and I know I may be getting to something else, but I would like to hear your view. I guess it's not a separate brief, but since you are here, let me abuse you. What happens if we become aware of certain things that it's one thing that you have clarified now, but we have had to go again through the through the bill. You see things that maybe border on failing the test of constitutionality. What do we do? Should we just say just because the president brought this thing back, we are seeing things which may be unconscionable as far as we are concerned, or perhaps because of some of the interactions that we have had, should we then just let it go and go back to the president? And yeah, I think more than anything else, I would like to hear your view on that. Thank you.
Thank you, Chairperson. So the design of the South African state is such that you've got the judiciary, you've got parliament, and then you've got the executive, which in many instances is expected to act as one in terms of, because it's established by a president who appoints a minister of finance and many other ministers to exercise certain functions on behalf of the executive. But it looks like the executive is working in a sometimes self-contradictory fashion, which ultimately delays the legislative process here in Parliament. I'll give you an example, not of this act that is on the table now, of the Minerals and Petroleum Resources Development Bill, Amendment Bill. It's signed by, it's passed by the Fourth Democratic Parliament. It's taken to the President and it's returned, I think, 12 months later on the basis that it's possibly unconstitutional. And then when it comes back to Parliament, the executive, a division of the executive, which is the Department of Mineral Resources, a component of it comes to argue that, no, that bill which was brought by the president, by us in the executive, it's actually constitutional. There's nothing wrong with it. And then it's taken back to the executive, and the MPRDA was passed, went through a process here, but more than 24 months later, taken back to the executive for signing. It's not signed. It's more than 3 years later now. The same situation we're facing now, that National Treasury, which is a component of the executive, drafts legislation, satisfies itself that it's legally permissible or it can be passed, it is within the Constitution. We entertain it here in Parliament. We reach the same conclusion. We agree with National Treasury that this is legislation that is consistent with the Constitution, but not only that, it is also consistent with essential international statutes around issues of financial crimes and financial intelligence. We satisfy ourselves, all of us, with the National Treasury, and it goes to the President, he brings it back. National Treasury, on behalf of the executive, comes and says, no, that is constitutional. I don't know, how we need to normalize that relationship of, perhaps the executive must be given a clearer mandate, chair by Parliament, that prior to the president bringing back legislation here which unnecessarily protracts it, there should be thorough work that is done in the executive, that certain legislation can pass the constitutional matter. Well, we know that there's politics behind it, but I think there must be a degree of sophistication when you want to object to legislation, because what we're being faced with here is just delay tactic by a criminal syndicate that is objecting to passing of legislation that is going to deal decisively with financial crimes. There's nothing which is being raised here. I mean, I don't think senior counsel even had to crack their heads over these issues. We could have given to people who have just graduated from university. They're going to reach the same conclusions because it's basic information. It's basic, it's basic that you can, in exceptional circumstances, conduct searches without warrants. It's provided for in virtual all legislations that have to deal with crimes. And we must never underestimate the gravity and the reality of financial crimes in South Africa. It's massive. It deprives people of basic access to resources that would otherwise better their living conditions. We'll listen to people who are going to speak later, who are even saying that the whole legislation must be thrown away. We'll hear them when they speak here in defense of a criminal syndicate. But, Chair, I think as a matter of principle, we should well appreciate that the executive brought the legislation back to Parliament and then came back to say that the legislation brought it back on the basis of it being unconstitutional. It's actually constitutional. If we treat the executive as one entity, so we must accept that that is what we're dealing with today, that the executive brought law to say it's unconstitutional, and then they come with senior counsel to say that actually it's constitutional. That is what we're dealing with in this current phase of these issues. We'll listen to criminals later, so thank you very much.
People who want to comment apart from MPs? Are there any other MPs firstly? No. Right. Anybody else wants to comment who's making representations here? Yeah. No, listen. Floyd, let's get something clear. From 1998, look at the records. Look at the Municipal Systems and Structures Bill. You were in your nappies then. When you were in the Communist Party, you wanted a popular people's power organ, right? And this Parliament, let me tell you, we have always allowed anybody and everybody to speak. When we did the Municipal Systems Act, there were people from Khayelitsha sitting in Old Assembly. Maybe, what's her name, Gay Davis was here then. But you were in your nappies. That bill went to the Constitutional Court. It was never challenged because we allowed anybody. This is what I would have imagined your party would love. That Parliament must become more relevant to the people. Anybody who's a South African citizen should be allowed to speak here. So Floyd, let's not have that discussion here. I will engage with you over tea, okay? Now, as for people heckling you and so on, you're a politician, take it in your stride. Okay, now let's move on. Now, on the issues that have been raised, I haven't come in yet, I'll wait for others. As for the issues that the two advocates have raised, is there anybody apart from the MPs who has a matter to raise or a question to ask? No. Mr. Manye.
Thank you, Chairperson. I'm rising on just two issues, maybe three issues. One, to object very strongly on behalf of Black Business Council and Progressive Professionals Forum that we're being insulted in this House. And I want to object that the Chair himself does not call a member of Parliament that is insulting public in this House. We can't be called supporters of criminal syndicates when we've got legitimate objections to the bill, when the constitution of this country allows for such objections. And when we do, we get called criminals, we get called all these silly names by members of Parliament in the presence of the Chair, and the Chair does not rule such a member out of order. So the first point, Chair, is that for us as Black Business Council, for us as Progressive Professionals Forum, we're asking the Chair to ask the member to withdraw those insulting remarks because we're not here to be insulted. Second point, Chair, on the program, the PPF is listed. So we want to save the time of this committee, Chair, and just say, within the BBC submission, the PPF submission is embedded. Safe to say, for us as a PPF, we just want to make, if the chair allows, one statement, which is going to take 1 minute, which will also respond to the two senior counsels that have spoken. And if you allow, Chair, for us as PPF, as we support the BBC submission, we are saying the fundamental issue here is that if we're here dealing with a security cluster making the kinds of arguments that the senior counsels are making, would be making sense. It is our view that this committee is making a fundamental mistake.
Mr. Manye, no. Mr. Manye, no, Mr. Manye, I'm chairing. You are no different from any other South African. You have no more rights. Now, firstly, on the matter that he said, I didn't hear you say the BBC is part of a criminal syndicate, but to the extent you're suggesting that, Floyd, I'm asking you to consider withdrawing that. That doesn't help. No. He didn't say that the BBC, so I don't know why you're picking that up. In the House, we've discussed this thing. You have the same rights here as you have in the House. You know this very well. You were in the presidency at one stage. But the lawyer will decide on that. Can you come back on that? On the matter of, which has got not any relevance to what we're looking at now, but since you've raised it, you can have the 15, what you could do is you could have 30 minutes if it's allowed. You can combine the two. It makes no difference. Who's after you? And I think we're saving enough time. Sorry? Who's it? All right, fine. But no, who's next after you? Is it Kasak? Where's Kasak? I think it was Kasak. Would you be okay to go 15 minutes further back? So in other words, let PPF and BBC have the first 30 minutes, and you come in and after. Is that fine? So you can have 30 minutes, no problem. On the matter of what we are looking at now, you can, when you're making your submission, we're asking you, do you have any questions? Not about what the committee is doing, and you're a bit late, but that's been covered, Mr. Manye. We're not going to allow you to come late, and then it's been covered already in the first 20 minutes. What we are saying, do you or anybody else here have questions about the presentations by the two advocates, Semenya and Gauntlet, on the issues of constitutionality and, in that sense, what we are looking at? On that matter, you can raise a question or two. Good.
Yeah, yes, Chair. I just want to know from the two senior counsels, when they raise the matters the way they do, to what extent, when they raise these matters, have they taken into consideration that the constitution of this country does not provide for this kind of investigative whatever to private sector, so to speak, does not allow for some inspector who must use his own discretion about what's reasonable and what's not reasonable. And Section 205, subsection 3 of the Constitution, Chair, is very clear on this matter. It says the objects of the police service are to prevent, combat, and investigate crime, to protect and secure the inhabitants of the Republic of their property, and to uphold and enforce the law. Nowhere in this Constitution is this right given to any other body, to any other entity. The argument made by the two councils seems to suggest that it's allowable for some parallel situation to happen, whereas the Constitution has confined that whole role to the police. Here I've quoted the understanding why the senior councils have decided that what the Constitution has demarcated as a role for the police, they make all these arguments to say banks must do the same. I have a serious problem.
Right. Anybody else wants to ask a question? Yes, Makosi.
they can even engage with the previous presentations. There is nothing that stops that. I'm just worried that if we keep on moving this way, we will end up not finishing the business of the day, because they will still have the opportunity.
You must remember we set a tradition, and this goes back to 1998, where we do not reduce, and this committee agreed in 2014, we do not use public hearings, what are called transmission bells. People come here, they take up their 15 minutes, they get on the next plane and so on. We've encouraged dialogue, so that we've often asked in the committees that I've been involved in, that people stay till the end, so that we can encourage understanding and dialogue. That's what a popular, effective parliament's been. This committee, until now, has accepted that process. But if the majority now want to change it for this meeting particularly, I am obviously forced to change it, but I'd like some rationale for why. Especially in a situation where at least 20 minutes ahead of time. And whatever happens, this committee has not usually ended long beyond the time. So I'm pleading that we don't, for this committee sitting, change the tradition we've set in this committee, at least for 2.5 years, and it's been around since 1988. But fine, if the majority want to stop this process now, it's a bit unfair because one person's asked a question, and these two gentlemen might be leaving in any event, I would imagine, around lunchtime. So they won't be here to answer. So for that reason, too, I suggest there's not many more people who want to ask questions. Nobody, in fact, so let's fall it away. So let it fall away. Yeah, thanks, my sister. It's just that we must do this thing the way we've been doing it since 2014, and you've been part of it. And there's no crime. It's 20 minutes. And really, can I make something very clear? You made the point, Advocate Gauntlet. I haven't seen you since you last appeared here. By the way, Makosi, you'll be interested to know. Jeremy Gauntlet used to appear here, the powers and functions of local government as against provincial government and what can Parliament legislate. So he used to be here then. Since then, he's fled the Parliament. I haven't seen him in any committees. And I don't know Advocate Semenya. I know him by reputation. And I just want to confirm that I had nothing to do. Once Jenkins gave me the names, we just said find an appropriate person. Then I have had no contact with you. Will you confirm? I don't have your cell number. I have nothing. I've known Mr. Budlander's father, who was NUSAS president in the 70s, right? 1971, I met your father in Cape Town when I was chair of National Youth Action. Yeah, Jeff Budlander was the president of SRC. He spoke to our organization. I've had no dealings. I don't even have either of your cell numbers. So I'm glad you said that, because I must tell you, I've been chairing committees since '98, and Tandy is absolutely right. I have never, Advocate Semenya, Advocate Gauntlet, come across this before. As illustrious as the lawyers might be, when they come here, you get, as Tandy says, 3 people with 3 different opinions. And it makes our life immensely difficult, let me tell you, because we're not lawyers. But in short, I want to confirm I had nothing to do with Advocate Semenya or my friend there. What's his name? What's your name? Steve Budlander. Yes. Thank you. Right, over to Advocate Semenya first, and then...
Mr. Chair, my learned leader, Mr. Semenya, has asked me to address the questions that have been raised, and if I could address them as they arose. The first question that arose was, I think, really a rhetorical one, but it's important just to emphasize it. It's that why would the Constitutional Court find against its own provisions? And although I think it was made rhetorically, it is just worth emphasizing. When the Constitutional Court declares a statute invalid, it does what's called reading in. It rewords the statute as an interim measure. And in both the Estate Agents Board case and in the Gartner case, it reworded the statute in very much the same form as this committee and the Assembly ultimately adopted. Now, obviously, the Constitutional Court cannot act unconstitutionally. That would be a contradiction in terms. So when one sees the parallels between this bill and the reading in orders granted in those cases, that is, in our respectful submission, a very strong indication that the bill is constitutional. The second set of questions raised by the second honourable member related to 2 issues. The one was, how do you measure the element of decency in relation to warrantless searches? And it is, with great respect, a very difficult question. But it's not one, I would submit, that you can resolve in the course of this debate. What one has to do is, as Parliament say, that all searches must take place in a manner that respects decency, and then allow the courts to interpret that word. So if there is a search which someone contends was not conducted in a manner with decency, then they will no doubt sue whoever conducted it or seek to set aside whatever was seized, and the courts will have to pronounce on what decency means. So it is a very legitimate concern, but it's not one that can be resolved. One has to leave a space for the court to interpret, and I think decency is as good as you can get it. The second issue that was raised by the same honourable member is the question of justifications, and the point was raised that it concerned the honourable member, isn't that a matter that is best left to the court of law? And with respect, again, we agree. What has made this set of opinions relatively straightforward and perhaps explains the degree of similarity is that very unusually there are 5 constitutional court judgments all dealing with these issues. And so often when matters come before advocates or parliament, they are res nova. But as my learned leader explained, this is not res nova. We have 5 judgments, almost all of them unanimous, given by the Constitutional Court. And so this committee can be satisfied that on the question of justifications, the court has already pronounced. And when my learned leader read to the committee the things that were said about urgent searches, 4 different cases where the court said, in urgent searches you can dispense with a warrant, it is made clear that that is a justification. The third honourable member raised the question of Chapter 11 of the Constitution regarding the security cluster and whether this is permissible as a constitutional matter to have these inspectors conferred with these powers. We would offer 2 responses. The first is that that isn't, as we understand it, a basis for the President's referral, and that's why we haven't addressed it. And we understand and endorse with respect the explanation given by Advocate Jenkins that this committee is, both in terms of the Constitution and in terms of the rules, bound only to consider the constitutional objection raised by the President. That's the privacy issue. But secondly, let me deal with the question. It is not in any way unusual or, in our respectful submission, constitutionally improper to have an organ of state conferred with search powers in a narrow regulatory environment. Could I give you some of the examples of which we are aware? ICASA has the power to conduct searches to regulate the telecoms environment. The Film and Publications Board has the power to conduct searches to regulate the films and publications environment. The Estate Agents Affairs Board has the power to conduct searches in relation to estate agents, and there are many others. That last example is particularly important because now none of those are part of the security services, but they are all conferred with these powers, not a general power to conduct searches or a general power to enforce criminal law, but only a narrow power to conduct regulatory searches in their area. Now, I gave the example of the Estate Agents Affairs Board. That's very important because one of the 5 cases to which we've referred and to which the President referred was the Estate Agents Board case. In that very case, what was at issue was whether officers of the Estate Agencies Affairs Board could have powers of search and seizure. And the Constitutional Court had no issue with them having those powers. They didn't in any way suggest it was improper under Chapter 11. The only debate was, were those powers sufficiently constrained to meet the Section 14 privacy interest? So our respectful submission, and it goes also to the later point that was raised by Mr. Manye, is that there is no constitutional objection to conferring these powers, which are conferred only for purposes of assessing compliance and only for purposes of a narrow industry on a body like the FIC or the Film and Publications Board or ICASA or the Estate Agency Affairs Board. And if there had been a problem, the Constitutional Court would have said so. The fourth question was about what if the committee comes across other things regarding unconstitutionality. I think I've addressed that, and Advocate Jenkins and my learned friend Mr. Gauntlet has addressed that. We agree that it's only open to the committee to focus on the constitutional issue raised by the presidency. And then there was the point made about a conflict between National Treasury and the President, which it seems to me is not appropriate for us to comment on, and we would leave that for others to deal with. And then I think I've already addressed Mr. Manye's question about the security cluster. And so unless my learned leader wants anything else, those are the issues raised. Thank you, Mr. Chair.
You want to say anything? No. All right, then to the Jeremy Gauntlet team.
Thank you, Chair. It's a very small team, as you can see. So, 3 issues which is in relation to which the various questions which they straddle. The first is the privacy issue. Honourable Member Topham raised it and a question in relation to it, or an observation. Honourable Member Tobias also. As regards the point made by Honourable Member Topham, with respect, one can't talk about, in the context of what we're examining, namely the issue of warrantless searches, that simply accept that the infringement of a right is a violation of the Constitution. As was explained earlier by our colleagues, there are actually two halves to the equation. You need A plus B to get to C. C is decision that there's a violation of the Constitution. A is the infringement of a constitutional right. B is a failure by the infringer to justify it. An example, this morning I was required to, at the entrance to Parliament, as a stranger in the old parliamentary term, to disclose my business, and secondly, to make available my bag for inspection. Now, undoubtedly, that is an infringement of my right to privacy. A very limited one, but it's an infringement of my right to privacy. The other ones, if I'm stopped for a breathalyzer test and things like this. Question is, though, is there a justification for it? If there is, then the answer is yes, your right was infringed, but B, the second part, there are important social and constitutional reasons why it was infringed, and a democratic, healthy society accepts that people late at night on the road should be stopped and asked to breathe in part with their breath or worse on the roadside. So that's a conceptual issue which, with respect, one mustn't start on the back foot of saying it's to be accepted that there is a violation of the Constitution. There isn't. There's an infringement of the right. One's looking at the justification, and that we've addressed. Honourable Member Tobias raised the important question, the concern about dealing with the issue of privacy in its implementation. And it's right. It's again one of those very difficult balancing exercises, exemplified by being required to give blood or give your breath or whatever the point may be, or to open your bag, as in the example. What we ask you to look at is, in terms of our endeavour in the draft that we've put before you, to get out of this debate about what is explicit and what isn't explicit. We have put into the, proposed putting into the text very explicit provisions about respecting the dignity, etc., and the decency of the particular subject of any warrantless search. And I'm referring particularly to the draft section 1D. It says it's got to be at a reasonable time, must. B, on reasonable notice where appropriate. C, with strict regard to an affected person's right to dignity, freedom and security, privacy and other constitutional right. And going on to deal with, again, decency. And only dealing, this is the important answer to Honourable Member Tobias, in particular, entering and inspecting only such areas or objects as are reasonably required for purposes of Section 45B2. That does not mean my sock drawer. It does not mean my private, what is marked as my accumulated love letters. This is a highly aspirational reference. An obligation to do this discreetly and with due decorum, causing as little disturbance as possible. I know of many statutes in the world which do not contain these sort of strictures, proposed strictures in them, which have not been successfully challenged. Turning then to the second set of issues which are raised, which is really Chapter 11, which seems to me to be linked to the third, which is what if, in the course of this exercise, something else is raised which is contended to go to unconstitutionality. We'd just like to affirm what our learned friend Mr. Budlander said, and that is, and as Mr. Advocate Jenkins advised you earlier, Section 79 is not intended to set up an endless ping-pong. It's intended to have the President there with the capacity, and if you like, the sort of dignity of office, that he's not there to rubber stamp, and if his advisors say, we think there's a concern, sir, before you sign, that there is this opportunity, not for him to change it, but to take it back to Parliament, Parliament to consider it, and thereafter for the process to continue, that if Parliament duly having considered says no, don't agree, or we think with respect there is something to this, and this should be adjusted or that should be adjusted, that what it does is to create, in relation to the President's concerns, that opportunity. It does leave the capacity, as the Chair would say, for every South African who is not part of that kind of process, of that check and balance process between the President and Parliament, to bring a challenge later, if so advised. But the answer is that in terms of Section 79, there is no mandate for an endless ping pong which can be set in train. But you can imagine, where would it get an end? Something additional is added which is not mentioned by the President, goes back to the President, so it comes on. With respect, it's not what the Constitution says. But may I give this substantive answer which reinforces what Mr. Butlander said to you? This, and it goes to my Rinderpest point earlier and Jackal point, this statute is intended to be a regulatory statute serving important financial regulatory purposes. To that end, there are inevitably people who have to carry it out. It's important to note that the inspectors of the Financial Intelligence Center are not primarily FIC officials, but they're employees of the supervisory bodies who are referred to throughout the Act, like, for example, the Registrar of Banks, like the Financial Services Board. And so, first of all, you have the fact that these are officials who have a knowledge in the industry. They're not trained as crime fighters. Their function isn't crime fighting. The statutory purpose and mandate is not to fight crime. It's rather analogous, and adding to the examples that Mr. Butlander gave you, Competition Commission. I don't know the health world area too well, but I would hope that the restaurants to which any of us go are regularly inspected by health inspectors. They have a regulatory function. They must go in there and perform it, as must happen with the competition inspectors. They go into premises. They have similar powers. Why? Because unfortunately, people don't comply with socially important acts on health and on various other areas of regulation. It does not follow that because they are doing that function, and more particularly under the constraints which are contemplated here, that becomes a security function or a policing function. It's not one at all, either in terms of the Police Act. It certainly doesn't fall under Chapter 11 of the Constitution. So, and I would add the last point, which is one made by Mr. Butlander, but very important. If there was such a fundamental, glaring problem, the Constitutional Court really missed out badly in Auction Alliance and the other cases by not saying, wait a moment, this act we're talking about, and this whole question of warrantless, etc., searches, you mean to say that it's not being done via Chapter 11, via the Police Act, with the Defence Force to help in certain circumstances? So I would suggest that the clear answer is that the Chapter 11 consideration is not correct, and that the second answer to it is that it is not properly to be raised when it is not a matter sent to you by the President under Section 79, and that what one is doing is retrieving a tennis ball from the far pavilion if one goes to it. But if one picks it up, I'm suggesting that it's going to turn out not to be it'll evidence not to be a tennis ball at all, that Parliament should approach it on the basis that if what it's going to now say is that there's this fundamental flaw in this Act, it's got a lot of cleaning up to do with estate agents and health inspectors and labor inspectors, another example, competition inspectors. Thank you, Chair.
This time, members only for clarity, is because we have to finally, not being lawyers, have to hear the different legal opinions, and then, with Advocate Jenkins' help, come to some conclusion. So the questions that will now be raised, if any, will be to the replies or anything else related to the submissions by the two advocates. Anything members want to ask? Thandi?
Chairperson, in relation to the suggestion of the adjustments that needs to be made to look at what the President has said, I want to be cleared as to what type of wording should we consider in this context to ensure that the interpretations are not having limitations. So both the senior counsels spoke to that issue of having to look at the necessity for adjustments. So is it too much to ask from both of them to give us specific legalistic wording to consider from them? It will make our work easier.
Can I raise this? That's a matter we can address later down the road. We'll have to consult, meaning we have to first, they have proposed concrete amendments, both of them, right? As a committee, we're not taking any decisions. Can we plead with members of the stakeholders who are here? As with every other bill, up till the day before we vote on it, you've got Ellen Wickham and Teboho Sepania. It'll be better to have some sort of legal opinion or legal substance to what you say, because this is different. It's not about policy issues. But up till the day before we vote, as with every other bill, you are free to make submissions. You or anybody wants to make submissions, it's fine. But we would like at least 48 hours before we vote on the bill, because then the lawyers have to process it and we need to give them time. So that's the first thing to say. On the matter of the concrete amendments, I think we need to apply our mind next week. When are we sitting again? Next week with it, eh? Yeah, whenever we sit, and then we will decide whether we call upon them using Jenkins' office and what the decorum is. I don't know that we've ever asked. Maybe we have, and maybe it's doable, but we keep that in mind, okay? So that's all I'm saying. Yeah. Well, you're asking them. They've already proposed 2 amendments, right? We as a committee haven't applied our mind to it. Now you're asking them to, before we made a decision on the matter, will you actually craft? They can only craft consequent to our policy decisions. Okay, so, all right. I don't know. Okay, well, okay, can you answer them? Whatever the meaning might be in the long term, I don't know, but fine. But before you do, can I raise some questions? I haven't asked any questions. But firstly, Mr. Manye, I will speak to Frank Jenkins and Floyd over tea, over lunch, and try to arrive at some agreement on this matter of how what he said. You may not have mentioned BBC, Floyd. Now, Mr. Manye, you'll have to take it that I'm experienced enough. I sit in that house endlessly for 23 years. Now, how many years is it now? 18 years. How many years have I been part? 1994, I can't add, right? It's 22 years. I've been chairing since 98. These issues have come up very recently as well, similar issues. And Mr. Jenkins guides us on it, as the Speaker has to also abide by the rules. And this is a parliament that does give you immunity and so on. You know all those things. You were here for a while, right, in the presidency. So what I want to say is, Floyd, even though I haven't got an opinion from Jenkins, I would plead with you, think about it, when we come back at 2, withdraw it. Because although you didn't refer to the BBC, it's reasonable to assume you are referring to them and others who share their views. So I'm asking you to think about it, following which I will just rule as a chair, Floyd. By the year 2050, you might be chairing this committee, right? You'll have to also abide by the rules. I don't make the rules. Yeah, well, fine, whatever. The point is, Mr. Manye, I want to assure you, but you can believe what you want, that what he said in the form he said it, he said before about other people. I have written him a letter. You recall, Floyd? The letter I wrote to you about another matter in December. That letter was seen by you, Frank Jenkins. I got a mandate to write to you about that matter. You never acknowledged it because you probably thought, who cares what the chair says, right? Now, fine. But I have addressed him. I'm not a policeman. I have to abide by the rules. There's freedom of speech here. So because he didn't refer to the BBC, he'll get away maybe. But I'm asking him to be reasonable. It's reasonable to infer he was referring to the BBC and probably the PPF. And I don't think that's correct. That I agree with you. But he didn't do anything wrong from what I can see. I wish I could ask the 2 advocates, actually, but then they'll say, no, don't draw us into this. So, Mr. Manye, will wait till 2 o'clock? And then there's also options. Unfortunately, we have discussed this thing. Members of Parliament can say what they want, okay? And then the poor person in the public out there who's not even there has a right of reply. You can petition. I've checked all of this, by the way, and guess who prompted all of this? Mr. Shivambo. I had to go and check all this out, and then we discovered, thanks to, I don't know whether it was him or somebody in the Speaker's office, they said, by the way, you need to know this. You can say what you like here as an MP. Unfortunately, I don't agree with this. The person who is subjected to ridicule or false allegations does not have an immediate right of reply. If I'm correct, what you do is you go to a petition to the Speaker's office, right? And then it's finally the Speaker's decision and so on. It's complicated, Mr. Manye. You should know all of this. You're not some peasant out there or rural dweller from, Swayamane. You've been inside the system. So, in short, what I'm saying is, Mzwanile, I'm saying to you, we'll sort it out by 2 o'clock. Good? Right. Let's move on to the questions. I have a right to ask questions too. Members don't agree with me, but I do. The first thing is, I want to suggest, by the way, though we are not advocates, I think actually in different forms, we've addressed many of the issues you've asked, actually. We spent many hours, I want the public to know this. Tandi, you've been raising it in another forum repeatedly. Tandi, Tobias Pokolo, and I were the people who sat most with this bill. Others have got other commitments. Some of them were not even here. But I want to assure, yes, Selo? Do you have a?
Yeah, I just wanted to follow up.
All right, but just very quickly, yeah, it's fine.
If you look at the preamble of this bill, it has been passed to comply with South Africa's international commitments to deal with the issue of terrorism, money laundering, and corruption. How do the advocates come to compare this with the health inspectors of a municipality? The people from the estate agents, but so it's not a small thing because money laundering is a serious crime. Terrorism is a serious crime that must be dealt with by the police. So I just need clarification because I think we are undermining the importance of this bill, which, by the way, the Black Business Council agrees with 90% of. Except that we just think, and that question was very important, the FIC is taking the role of law enforcement because these are serious crimes. Thanks. And giving them to people like banks, supervisors, and all that. Thanks.
That's a very fair question. Okay, fine. Can I raise this? Jimmy, you're going to be allowed, Mzwanele, you'll be allowed to speak. So I want to guard against now abuse of this process, okay? But I'll give both of you 2 minutes each, and that's it. Mr. Manye had his hand up first. Dr. Baloy had a hand up second.
No, thank you, Chair. First, I wanted to just put on record that the explanation by the two senior counsels I don't accept. The second point is to make the second point, Chair, is that when senior counsel Gauntlet made his elaborations, I was very happy with the point that he made, which has inadvertently actually supported the points that we're making. He said, Hansard will show, he said the inspectors of estate agents, boards, and whatever else are not trained in crime and whatever, are trained as specialists in whatever they do. Now, like my colleague Yasilo has already made a point, that the issue that we're dealing with here is actually a criminal issue, because our compliance as South Africa to FATF is our compliance to money laundering, which is a crime, is a compliance to terrorism issues, which is a crime, and therefore to take some civilians and to give them the role that they have not been trained for and assigned for by the Constitution is unconstitutional. So I want to say that I think that explanation that these inspectors of regulatory other things, the fact that they're not trained in criminal activity and whatever, is exactly the point why they should be disqualified from doing this. This is why it's incorrect to try and run a parallel police service. Thank you.
Mr. Baloy?
Yes, thank you, Chair. I think maybe they can help us understand unwarranted searches by the banks are beyond coming to my house, but going into my bank statements, going into all the information about me. And at the end of the day, what are the limitations there? I just want to emphasize the point about the banks. They are already very powerful. They run our lives literally, and I'll refer to parts of it in my presentation. But do they really need the powers from other organs of state? Because those of us who come here rely on people sitting around this table, this room, to make sure that our rights are not violated as legislators. We hope that you will not give the banks unfettered powers, that they already have too much power as we speak.
Continue, I was asking questions. We'll take all in one pool, and we're now going to move on to actually yourselves, BBC and PPF together. You can have up to half an hour. The first is to once again repeat. I'm a bit surprised, colleagues. I think the DA was there a lot, and I don't think Mr. Shivambu, because he has other matters. But actually, you know what I'm surprised about? And I want the public to be aware of this, that actually we dealt with most of the issues. We don't have your legal and intellectual prowess and the way you articulate it. You know, you have vivid images and anecdotes, examples. We don't have that capacity. So it's wonderful to hear both of you. We don't have that skill, but hey, quite frankly, there's very little both of you have said that, Tanti was saying this in another forum yesterday, we didn't look at. All these issues about where does the right of privacy start and the right of the state to intervene. The DA is politically predisposed to concerns about that. That's the inherent policy. I belong to a particular section, not just the ANC, right? And we have a left wing, so to speak, concerns about what's happening in the state at the moment. So in a strange way, in my unconscious ideological biases, I also had some concerns. And Tandi and others raised, so actually I'm a bit surprised, frankly, how thorough a job this committee has done, notwithstanding what some people will say. Secondly, the question I wanted to ask is, the interpretation I want to understand, right? What you are saying, and just tell me if I'm right or wrong, to simplify it for a politician, is if the power that the inspectors currently have is in and of itself unconstitutional, then A, the Constitutional Court would have said this in the Estates Agency case. It would have said, no, it's not a matter of circumscribing the power. It's wrong to even give that power. That's the first point you're making. The second is, if the power that the inspectors have in this bill is in and of itself unconstitutional, the presidency's lawyers would have raised it. And they are saying much the same thing as the court is, that actually circumscribe that power. Thirdly, one can deduce from both of these things that, that actually, now I think I'll drop that point. Just leave this for now because it makes my life easier and it makes your answering probably easier. That's the next thing I want to ask is, you're saying that if in looking at this specific clause, is that what you're saying? This specific clause, we find, I think that's the point I think Makosi raised, in this specific clause, call it 32, that's how we see it, right? 41B, 45, but in our bill, the bill that's before us, it's called Section 32. You're saying that even within Section 32, if we find another subclause or provision that is unconstitutional, we can do nothing about it? Or are you saying that as long as it's outside Section 32, then you can't deal with it, but if it's an incidental or related matter to what the President raised in terms of 79.1, then yes, if you can show that it's related. The next thing I want to ask is it possible for the presidency's lawyers now, having, I gather this might have gone to them, all the submissions, including your 2 submissions. What if the presidency's lawyers look at your submissions, right? And then they think things through carefully, and other submissions that have come, all have gone, by the way. We haven't, is that right? All's gone to the people you sent last night. Is that right? All the submissions. Yes or no? Please mention it on record. I want, because it might go to the Constitutional Court. I want you to answer.
I have not sent any submissions to any other stakeholders besides.
No, but the ones I asked you to do last night. Yeah? Oh, that's all the submissions that came here. Good, right. So it's been sent. The next thing to say is, what if the presidency now, and the president, having heard the lawyers, says, look, having looked at the matter further, I feel now, based on my lawyer's advice, that there are other provisions in the law, in the bill, that are unconstitutional. Can you write a second letter to us? You talked about ping pong, but is it not reasonable for the presidency's lawyers to say, having considered everything, we now realize, having read some of the submissions and may not agree with you, that actually there are other, can the presidency, in terms of the Constitution and the joint rules of Parliament, come with a second letter that says that sort of thing? In our report to Parliament, can we actually say, while we are restricted to 79(1)(c) restrictions, and it applies only to the scope of the warrantless searches, what we pick up are 2 or 3 other issues that we need to